I'm Rick Hasen. I'm a professor at UC Irvine School of Law, where I specialize in election law. Well, let's start at the beginning, first principles. What is the problem of money in politics? For about 40 years, the discussion, I think, has been misfocused with an emphasis on the question of corruption or the appearance of corruption. And all campaign finance laws are justified on these anti-corruption grounds. The reason for this is that in 1976, in the US Supreme Court's case of Buckley versus Valeo, the court held that when a campaign finance limit is challenged as violating the First Amendment rights of free speech and association, that the only interests that are permissible to potentially justify these limits is preventing corruption or the appearance of corruption. So the whole talk has been about corruption. And I think that that obscures what I consider to be the fundamental problem with money in politics today, which is not about corruption. I don't think we have, at least on the congressional level, a lot of politicians that are on the take. If we think of corruption, the classic corruption is a quid pro quo. I'll give you $10,000, you'll vote for my preferred bill. The problem is instead one of inequality. We have a system where those with wealth have a much greater chance than everyone else to influence both electoral outcomes as well as policy outcomes. And in the book, I talk about the social science evidence to back up this claim. It's not a crass argument that money buys elections, but it is an argument that if voting and elections are like a lottery, we're giving many more tickets to those with wealth to be able to influence the process. So the problem is really about inequality. And the problem with that, the problem with discussing that, is that the Supreme Court since 1976 has said that leveling the playing field, political equality, is an impermissible interest under the First Amendment. It's a forbidden interest. Just getting the whiff that equality could be an issue could doom the constitutionality of campaign finance law, as we saw in a recent Supreme Court case involving Arizona's public financing system. And so we've had this warped discussion when I think what we really should be talking about is the problem that those with great economic wealth are able to take their economic wealth and translate that into political power in a way that undermines the equality that is really part of our tradition and our American democratic set of values. I would say two things about the relationship of corruption to equality. The first is that the word corruption is quite malleable. And if we were writing on a clean slate, what Lessig calls dependence corruption, the elected officials being dependent not only upon the people alone, but upon the donors, the donor class that runs the money primary before the election. Could you call that corruption and still be speaking the English language? Absolutely. But the Supreme Court has read the word corruption much more narrowly. And I argue, and Lessig has finally agreed, and I point you to his new book, The Republic Lost 2.0, a significant rewrite. He admits that much of what he called corruption is also, I would say, is instead a concern about political equality. And so Lessig has turned to recognize that the fundamental problem when donors bend to the wishes of the donor class, when elected officials bend to the wishes of the donor class, the fundamental problem is one of inequality, not corruption as the Supreme Court has defined it. The other thing I'd say is that certainly campaign finance limits may be justified on anti-corruption grounds and a narrow understanding of the word. So for example, the idea that I can't give $1 million if I had it to someone running for Congress, well, that certainly could be justified on anti-quid pro quo grounds. It'd be very hard for people to ferret out if I've given $1 million whether that candidate has made me a promise to do something. So there are anti-corruption arguments. But if you think about this fundamental distinction the Supreme Court makes between contributions and independent spending. So suppose someone spends independently, does not coordinate with the candidate, there's no possibility of an illicit deal. It's still problematic in my view. I don't think we can call that corruption. We could say the system is corrupted, but I think another way of saying that, and more straightforwardly, is to say that we have an equality problem. That I may feel as intensely about the political process as you do, but if I have much more money than you, I have a much greater ability to influence not only who becomes elected, but what policies elected officials pursue once they are elected. Well, if you go back to the Buckley decision, 1976, post-Watergate, Congress passes a set of campaign finance limits, some pretty strict limits, not only limiting, for example, someone from giving no more than $1,000 to a federal candidate in an election, but also limiting that person, that individual, from spending more than $1,000 relative to a federal candidate. So under this law that Congress passed in 1974, at that time, if you wanted to take out a full-page ad in the Washington Post saying vote against Nixon, that would cost you about $5,000. That would be illegal. And the Supreme Court thought that this limit on independent spending raised serious concerns about speech and association, and I think the court was right. The question was what to do about it. And the court said that contributions could be limited to prevent corruption. But then the court said that independent spending did not have the potential to corrupt, and therefore corruption couldn't be the basis for limiting, say, that $1,000. And then when the court turned to the question of whether leveling the playing field could be a reason to limit money, the court was concerned. The court was concerned, rightly, I think, that we want to have robust political competition. We want people to be able to engage in rigorous competition for people's votes. And so the question was, could you justify limits on the basis of political equality? In 1974, the court said no, that line violated what the First Amendment was about. I think since that time, there's been a lot of support for that position by some, but there's also been a lot of criticism of that position. And I would argue that if you look at some cases that the Supreme Court decided since Buckley, there's been wavering on the equality point. So I'd point you to the 1990 case of Austin versus Michigan Chamber of Commerce, in which the Supreme Court upheld a limit on corporate and labor union political activity. The court said, corporation makes money selling shoes or software or whatever. That corporation cannot take money from its general treasury funds and spend it on elections. It could set up a PAC. It could solicit its officers, managers, shareholders to contribute to that PAC and use that money. But you can't take the money you make from selling shoes and use that in the political process. And the rationale the court gave, which the court dressed in an anti-corruption argument, but I think was actually an equality argument, was the concern about what the court called the distorting and corrosive effects of immense aggregations of wealth on the political process. Now, the court limited that to corporations, called it corruption, but I think it really was an equality argument. And Chief Justice Roberts, in his concurrence in the Citizens United case, a case which overturned Austin, as well as overturned another case, said this was really about equality. And this is really the question that the Supreme Court has struggled with in the background, I think, in many of these cases. The court still speaks the language of corruption, but I think at least for the 4 justices who've dissented in Citizens United and in these other recent campaign finance cases, there is a concern about political equality and a recognition that the First Amendment balance is a difficult one, and that there are good arguments to be made that we should not allow the translation of economic power into political power so easily. I don't know how much there is policy confusion as much as there is a problem of the Supreme Court truncating what would be an otherwise natural conversation. That is, advocates know that speaking the language of equality makes it much less likely that a court's going to uphold the laws. Just look at this Arizona case, where Arizona passes a public financing plan through voter initiative. One of the things it does is it says that if you agree as a candidate to take public financing through this voluntary public financing scheme, and you face a super PAC on the other side, or a self-funded millionaire on the other side, you'd get extra public financing. And the Supreme Court considers whether that violates the rights of those who would spend money against these participating candidates. And the court, I think, somewhat surprisingly says, yes, it would. But what's most interesting to me about that case is the court says, well, we think this was put put in place by voters in order to level the playing field, and that's impermissible. And so those who advocate, for example, for extra money for small donors, as they have in New York City, as this multiple matches. So you give $100, it might be worth $400 or $600 to the candidate. People are very wary of discussing this in terms of political equality because they know that as a litigation matter, it's very dangerous to do that. And so I think, I'm not litigating these cases. I think I can speak the truth, but I understand that others may not. And the other thing I'd say is that in many voters' minds, or in many politicians' minds, these concerns about corruption and equality meld into each other. And the only reason we have to draw distinctions and say it fits in this box or that box is because the courts have told us to do that. And I think many times when a politician or a reformer talks about corruption, I'd say it fits more closely into the equality box. But who cares? The only people who care are people who are trying to litigate these things. And if I could sit down with them in a room for an hour, I might be able to convince them they're really concerned about equality, which is something that they might not want to admit, even if they agreed for litigation purposes.